the latest edition of the PLF Supreme Court Show. Joshua Thompson here, joined by PLF attorneys Damian Schiff and Oliver Dunford. Oliver and I are at the Federalist Society's National Lawyer Convention. We're in our hotels. Damian is in the snug confines of his Sacramento office, looking as dapper as ever. We have obviously the big news of the week was the tariff oral argument, which you fine gentlemen recapped nicely a couple days ago. But there has been more happenings at the Supreme Court this week that we wanted to recap here at the PLF Supreme Court Show. We do want to at least touch on every oral argument that the Supreme Court does and talk about any opinions or other happenings. And this morning, before we get to the other oral arguments of the week, we had a interesting order come down. Damian, can you fill us in on what that order is all about?
Yes, it was a lawsuit brought by transgender individuals who wanted to block a Trump administration change in policy. Apparently during the Biden administration, the State Department changed its policy to allow transgender individuals to have their passport changed so that where it says on the passport what your sex is, you could then have it reflect your gender identity. And the Trump administration, consistent with its policies in other areas concerning transgenderism, changed that policy. The district court granted an injunction against the change, and the Solicitor General sought, shall we say, interim relief. That's emergency relief is now, I guess, improper. Anyway,
it's not shadow docket.
It's not shadow docket. In any event, the Supreme Court, in a 4-paragraph order yesterday, stayed the injunction and said that the government is likely to succeed, that there's no constitutional or other harm here. I think more or less what the court is saying is that it's just truthful information, because the passport is meant to convey your biological sex. Now, it may be that as a transgender person you don't associate with that, but that doesn't change the fact that that's what the passport is supposed to be conveying. So without any sign of animus, that's pretty much okay. Plus, it's interesting too, because foreign affairs played a role. Obviously, what goes in your passport is a big deal with how we interact with foreign nations. It's interesting too, because this kind of came up in the tariff argument too. And here is an example where the court is receptive to that, and in fact relied upon the foreign affairs aspect of it to show irreparable harm to the government if this injunction were to remain in place. So Justice Jackson wrote a 10 or 11-page dissent, joined by Justices Kagan and Sotomayor. But again, it shows another win on the interim docket. I was listening yesterday to one of the FedSoc presentations, and I think as of yesterday, this term, or this year at least, the administration is 22 out of 24 in seeking interim or emergency relief. So now that's 23 out of 25. So it does go to show you that not only is the Solicitor General doing quite a good job, but I think it also goes to show you this growing chasm between how the Supreme Court views interim relief and how the district courts are viewing these policies from the Trump administration.
Yeah, it could also be, I don't think the administration is seeking review of every loss that they take in the circuit courts. I think they're probably selectively choosing the ones that they think they can win, and that's probably skewing the results a little bit more than I think is obvious on the face of it. Question about the opinion: is the claim here that being required to list your biological sex, it's discriminatory, it violates equal protection, or what is the underlying claim?
Yeah, there's not a lot of discussion of that in the order, but I suspect, I think it's like an animus claim in part, or it could also be a rational basis claim, and that the harm is that for a transgendered individual, there's psychological and other harm by requiring to have on this formal document a sex description that doesn't match your current identity. Now, again, I think the comeback from the government is, well, that's fine, but the passport has never been intended to convey gender identity. It's always been intended to convey biological sex, which again makes sense, because in a lot of countries, that's really, where transgenderism is not as accepted. I mean, that's really what they're looking for. So I think it was more or less an equal protection animus claim, and the court said we just don't see animus. It seems to be a rational basis for it.
So this goes back down to the district court now?
Well, that's a good question. Yeah, I imagine the litigation is still proceeding because there was only interim relief that was granted in the district court, and this is just a stay. I don't think that there is. I don't recall there being a conditional cert petition being submitted yet. Anyway, so probably a while before it gets up to the Supreme Court.
Okay. Well, thank you for that. Let's move on to the week of oral arguments. The week started out with 4 arguments before the tariff case, and the first one, I believe, was RICO versus United States. This case dealt with, as we previewed, it's the supervised relief issue, where a woman was on supervised relief after committing some drug offenses, and while on supervised release, she absconded. While absconding, she committed violations of the terms of her supervised release, including not to commit any other crimes. Now, some of the crimes that she committed while on supervised relief fell within what was originally that time window of supervised release. Let's call it 6 years. It might have been 4 or whatever. And some of the crimes fell outside of that time window. The government wanted to say, while she was on supervised release and absconded, that told the ticking of that 6-year supervised release. So any violation she committed within that was still while she was on supervised release. The defendant in this case wanted to say, no, the one crime that I committed after the 6 years had expired was not during supervised release because it was only a 6-year period. This matters for what the sentence will be or what enhancements you can get whether you're on supervised release. I don't know if you've had a chance to listen to the argument, but it was really interesting insofar as I'm hearing a big wind tunnel right now. I don't know if you guys are hearing that. Anyway, hopefully that's not being recorded. But there were 2, I think, logical problems, one from each side. On the side of the defendant, the first question out of the box from Justice Thomas was something to the effect of, this is called supervised release, and you're not being supervised. Why wouldn't this be told? How is it possibly supervised release? And the advocate had a good response to it. They acknowledged how that is, that sort of like has a natural force, the natural understanding of supervised release is you would be supervised, but then pointed out the problem with the government's argument is if you are on supervised release, then if you are not on supervised release because you're not being supervised, then the conditions shouldn't apply either. Either you're on supervised release and those conditions of your release apply, or you're not on supervised release and the conditions don't apply. And because the government wants it both ways, wants to say because you absconded, you are not on supervised release, but you violated one of our conditions of supervised release while you absconded, so we can still hold you liable for being on supervised release. Does that make sense? Am I explaining that well?
Yeah, that's right.
And the government's response to that is, look, nothing says that it has to match up perfectly. Just because you're on supervised release, but you don't get to satisfy all of the conditions of your supervised release unless you are satisfying all the conditions of your supervised release. So it's not illogical to say that you were complying with some but not complying with the others, and that's just how it works, which is also, I think, fair. As I read the argument, it felt like there was just, it's going to come down to what does the statute say, and it seems like the defendant or the petitioner in this case had a pretty good statutory argument, particularly when there's a whole statute dealing with absconding when you are a prisoner, so not on supervised release, but when you're a prisoner and there's certain things, and Congress didn't see fit to incorporate a lot of that language over into the supervised release scenario, which lends credence to the idea that no, this is actually a strict term. So despite sort of the intuitive force of it, of supervised release being supervised and that not happening here, I do think what the court's going to say is, Congress can correct this, but as far as what the statute says it's a 6 years fixed period. Once that elapsed, we can still prosecute them for absconding. We can still prosecute them for the crimes they committed, but you don't get this extra enhancement. And for the government's part, they sort of conceded, I think, the main problem here is that, like, yeah, this can all come before the judge, and the judge can understand it all, and the sentence can be imposed notwithstanding, so that there's so much discretion in sentencing for somebody who's absconded. Whether this falls within that time period, doesn't sound like it's going to make a whole hell of a lot of difference to the ultimate punishment that this person faces.
Yeah, it seems like there's not really a practical problem here. The issue is whether, as you said, the release time is told or whether it can be revoked. And the petitioner's lawyer said at the revocation hearing, which is what he's advocating for, the judge can rewind the clock and require the person to start all over. So, as you point out, there could be some enhancements on the crime that was committed after the original term expired, but then she can be put right back on supervised release and other things. Right. And the only thing I got out of it is that there's a difference between parole and supervised release and some other things. And some of it seemed to be, do the police have time to do this? And yeah, it seems like a lot of talking about not a huge practical problem.
Yeah.
So why do you think the court took this case?
That's what I was implying. I don't know. It's just strange. Maybe there's a circuit split. I don't know.
Yeah, I think there was a split of some kind, but it does feel. I mean, maybe it would make a difference in another case, although it seems like there's so much discretion for sentencing judges in this space that it's not going to. That's at least my read, and I think the government conceded as much. But anyway, I'm predicting a 9-0 in favor of the petitioner.
Interesting.
I thought the advocacy was good on both sides. I think both sides were pretty smooth and high quality advocacy.
Well, and they both knew the background well. In other words, the lawyer for the petitioner, I think, is a defense lawyer, criminal defense lawyer, so knew some questions that maybe an appellate specialist would not have known, which was helpful to Justice Jackson, I think, in particular.
Yeah. Moving on, I thought I think it's Hensley versus Fluor Corporation was a very interesting argument. This is the case, as we previewed, that dealt with there was a terrorist attack on a military base in Afghanistan. The terrorist was an employee of a company there doing work on behalf of the military, and the plaintiff brought suit in state court in South Carolina for the breach of contract and tort. The breach of contract got thrown out, but the tort claim survived, and the corporation sought to defend the tort claim on the grounds that they were immune from suit in state court because they were a government contractor working in a war zone, and they should be immune from suit in state court. This argument starts out, I think I want to read what Justice Kavanaugh's very first question was in this case, which I thought was great. And how do you respond to this? This is right out of the gate after Justice Thomas asks his. Justice Kavanaugh pipes in. He says, "What do you do with the entire text and history of the Constitution, which says war-making, war-fighting comments on the federal interest in the states? Article 1, Section 10, and otherwise have nothing to do with how America conducts its operations in a combat zone. So if the first question from the justice is, what do you do with the whole text of the Constitution that's against you? That's a good way to start. And that is the theme that Justice Kavanaugh, he was very, as fiery as I've seen Justice Kavanaugh in an argument, he kept on coming back to this idea that there are certain interests that are quintessential federal. This is a war zone and an active war zone. Apparently there are like rockets being fired into this base regularly. I think his big concern is, and I think this was probably shared by one of the justices below, or judges below, is if the government contractors can be hailed into state court, they can be hailed into 50 different state courts, that is going to, in some ways, dictate how these private companies, these private government contractors interact with the federal government in war zones. And if we think that the federal government ought to have a lot of leeway and discretion for how it conducts its operations in war zones, we certainly don't want their government contractors worrying about how their actions will be perceived in a future state court tort lawsuit against them. And whether they can then bring the government in and cross-examine the government, because they're all going to be pointing fingers. The government contractors are going to be saying, no, it was the U.S. government that let this terrorist on the base, and the government's going to be saying, no, it was this corporation which was liable, which in fact the government has made a finding, and that's the rub of the plaintiff's case. The plaintiff's case is we're not dealing with a situation where someone was doing what the government said. The government has already made a finding here that the private corporation, the government contractor, was negligent, and therefore the government ought to want non-negligent government contractors. Now, of course, Kavanaugh's response to that is, of course the government's going to say that. And when you go into state court, the government contractor is going to point the finger at the government. They're going to be pointing fingers. That's exactly what we don't want to have happen, and that's why these are uniquely federal interests. Yeah, so that's I guess my recap. I think the Kavanaugh questioning was the most interesting. The response and the government that's was on the side of the corporation here. So you had both the government and the corporation in unison that there ought to be immunity here. Of course, if they lose that, they're going to be on opposite sides of the case down below. But an interesting case.
Yeah, the one question and Justice Thomas, I think, started the questions, how far should this preemption go? For example, should it apply to people who supply food? And it seemed like a consensus emerged that people who serve food or prepare food on the base are probably covered by this preemption. But what about if you have an American company that prepares food in America, ships it to the battlefield? What about that? And at one point, that seemed probably too far afield. That probably could stay in state court. But at one point, the petitioner's lawyer said, well, first of all, we're dealing with something that occurred on the civilian part of the base. And Alito and Kavanaugh could barely control themselves. And Kavanaugh said, it's bagroom. Come on. So it seems like most of the justices will say if something happens in a military base on foreign soil, that's going to be covered by the military and Article 2. And as Joshua, as you pointed out before, the Constitution is probably going to preempt that claim. And Justice Kavanaugh asked the petitioner's lawyer, could Afghan law apply? And he said, yeah, it might. And Kavanaugh said, well, this is just getting ridiculous. Now we're going to apply the law of an enemy state. So I predict that the petitioner will not win this case.
See, I'm let Damien talk inside. I'm not as sold on that. I kind of think they are going to win. Although it may be something where they really carve out a narrow, it's got to be like an active war zone in a foreign country. Because I thought the petitioner, well, as Justice Kavanaugh points out, it comes down to what the baseline is. Should the baseline be that we presume this is preempted unless Congress acts, or should it be what it is with all other actions, which is that there is a state court action unless Congress grants immunity, and Congress could certainly go in quite easily and grant immunity here. They had some tough questions where I don't think because they're like, what's an active military operation? Like, would it be someone in San Diego serving food that if that food will ultimately be shipped there? And I don't think they had great answers for that. So I'm not sold. I'm not sold that they're going to lose.
Interesting.
It is interesting. Again, when we talked about this case last time, there's the other case that will be argued, I think, in December, Chevron versus Plaquemines Parish, which is kind of a similar thing where a federal contractor, wartime contractor, is arguing that it can remove its case where it's sued by plaintiffs under state tort law. And it can remove it on the basis of federal contractor immunity. And the Fifth Circuit adopted a fairly narrow understanding of when you can be immune as a contractor. And interesting enough, the Solicitor General is supporting, at least until now I think, is supporting the challengers, I believe, saying that it's not immediately removable. But I might be misremembering. The other point I wanted to make is just that Justice Kavanaugh, again, seems to be the leading member of the court for protecting executive prerogatives and discretion. That seems to be his one of his most significant projects, shall we say.
On that point, yesterday at the National Lawyers Convention, Justice Kavanaugh spoke, and he started off speaking about how meaningful his time in the Bush administration was and how impactful it was as his role as special counsel. But the reason why I want to elaborate a little bit on why I think the petitioners might win is because Kavanaugh was so animated. I think he could sense that the other justices were not really seeing it his way. At one point, Justice Gorsuch started asking some questions, and Kavanaugh butts in. He's like, and then Justice Gorsuch says, "Hold on, my friend, hold on. You'll get your chance." And Kavanaugh says, "Well, I'm ready for it." So, a little banter from the justices there. But Jackson would come back with some sort of helpful questions for the petitioner, and Kagan and Sotomayor and Gorsuch, and Kavanaugh was always right there to back them up, which I thought was really if I have some critique for the advocacy here, I thought. I don't think the petitioner was as smooth as maybe you would expect someone from Consovoy to be. It felt like a lot of times he wasn't giving the answers that any of the justices wanted, so they started just arguing with each other, which you can see happen in some arguments, and the justices were going back and forth, and the questions to the petitioner would be like, "Right? Did I get that right?" He'd be like, "Yes, yes." So it was a lot of that. But Kavanaugh certainly leading the charge for the government in this case. Moving on to Tuesday's arguments, these were, I think, two of the shortest arguments in Supreme Court history, at least modern Supreme Court history. These are two that you previewed for us, Damien. Why don't we start with Coney Island, where Mr. Ginsburg was making his inaugural Supreme Court argument, and I thought he did a fine job.
Yeah, he did a nice job. Admittedly, it had to feel more of an appellate argument than a Supreme Court argument in terms of his answers, but it was very competent. And I was reading an article where he was interviewed, how he said that there were a lot of firms who asked if they could take it over, and he said, "No, this is really my my shot." The issue again is rather abstruse one under Federal Rules of Civil Procedure. There's a Rule 60, which allows parties after a judgment has become final to get relief from it, from the district court for a variety of reasons. And one of the reasons that the rule lists is if the original judgment was quote unquote void. And there's a time limit built into the rule. And on its face, it seems to say that whatever the reason for your request for relief, your request has to be made within a reasonable amount of time. And Coney Island was arguing that when it comes to void judgments, like the judgment here, where a creditor got a default judgment against it, but there was never proper service of process, so there was never personal jurisdiction. That's a void judgment. Coney Island said, in those cases, there is no time limit, that you can always seek relief. And basically I got the impression that every lower court, other than the lower court in this case, had agreed with that, and had said that, yeah, there effectively is no time limit. And somewhat interestingly, I think the court is pretty much going to rule unanimously in favor of the respondent, that no, actually, the rule quite clearly says reasonable. Reasonable doesn't mean no time limit. It did seem like the court was trying to give Coney Island maybe an out. Justice Gorsuch suggested that maybe they could put something in the opinion to say that there's another provision of Rule 60 that allows you to initiate an entirely separate action to get relief.
Mm-hmm.
And apparently it's rarely invoked. There's not much case law how it works, but Gorsuch was suggesting, maybe you could try that. The facts weren't, I was just going to say, Oliver, I mean, the facts weren't real great for Coney Island because it did have actual notice, or at least that was the argument, that it had actual notice for a long, long time. It just wasn't legally noticed properly.
I just wanted, when you were talking about Justice Gorsuch asking the petitioner's lawyer how they could write the opinion, he almost talked him into it. Justice Gorsuch said, "Are you waiving that? Well, we're not relying on that now." And I'm just, "Are you sure? Well, you write the opinion," and then he goes, "Oh yeah, okay. Well, if you said this, that would be helpful."
Yeah.
What was interesting is Lisa Blatt, a very prominent practitioner, was for the respondents. I don't know if you guys thought her performance all seemed to be very subdued and also not that long. But she had a few quips. One of them was talking about the court of clowns, this idea that if you have a truly an out of left field judgment that is super void, I guess, as opposed to just regular void, maybe you might have more time in order to seek relief. One problem that I think the petitioner had here from the get-go is that just because a judgment is quote unquote void, which means it has no legal effect, that doesn't mean that it actually has no legal effect. What that means is that if a court then determines that it's void, then it has no legal effect. But if you never seek relief, then yes, actually even a void judgment does have legal effect. It's just that void judgments you can usually attack collaterally, and under Rule 60 you have more time in order to get
Interesting.
relief. So that's something, because the petitioner kept going back to, how can we be bound by something that's void ab initio? And the reality is, well, even you acknowledge, if you hadn't filed 60 motion, you would be bound by it, right? Despite the fact that you think it's void. So anyway, nice job. I tip my hat to him. The briefing was well done, Mr. Ginsburg, and argument was nicely done.
Yeah, Lisa Blatt had the other line in there that I remember where, I forget which justice asked her, she's like, well, aren't all of the courts of appeals in one way? And she's like, well, I had all the courts of appeals in one of my opinions last year, and you still ruled against me. And
Yeah.
I think Alito got a kick out of that.
Yeah.
I agree with you. I think the petitioner's got a tough row to hoe here, and but it's I know that Lisa Blatt's not everybody's cup of tea. I do enjoy her. I think she was subdued here compared to some of her arguments, but still, she's got a manner that I think is very effective, and she's obviously very bright and did a good job for her side.
Yeah.
I think next is Hain. Am I getting that right? Hain Celestial Group versus Palmquist?
Yes. Yeah. So this is another short argument, another kind of an esoteric issue dealing with fraudulent joinder. I think that's the phrase. Basically, this is the issue: that if you're a defendant in a tort action, and this is a products liability action, the plaintiffs are parents. They say their child developed autism by eating the defendant's baby food. When you're a defendant in a tort action, generally speaking, you don't want to be in state court. I think that's kind of the general understanding of defense counsel. You want to be in federal court because you feel like the jury pool is broader, the judges might be a little less sympathetic to plaintiffs. You think you're going to get a better shake. So even when sued in state court, federal defendants like to try and remove the cases to federal court. Now, typically, these cases only get into federal court under the idea of diversity, meaning that all the parties are from different states, and that's a type of case the federal courts can hear, even if the merits are state law. Plaintiffs know this, and they try to get around it by making sure they include in their complaints at least one defendant who is in the same state as the plaintiff. to defeat diversity. And that's what the plaintiffs did here. They not only sued Hain, but they sued Whole Foods, the grocery store that sold the baby food, and Whole Foods is based in Texas, where the plaintiffs are. So they thought, okay, now we're master of our complaint, we've kept it in state court. The defendant, though, successfully convinced the district court, the federal district court, that no, Whole Foods really has nothing to do with this case. It was just fraudulently joined in order to prevent the case from being in federal court, and the district court agreed. The case proceeded to trial, and ultimately, on the merits, the Hain won. And on appeal, the Fifth Circuit ruled that the Whole Foods should not have been kicked out of the case. And so basically said, well, since Whole Foods should have been involved all the time, it wasn't subject matter jurisdiction, so the whole thing has to go back. So at the Supreme Court, the argument, Ms. Sarah Harrington for the plaintiffs did a very nice job, accomplished advocate. Her point was basically one of judicial economy, is that there's no doubt that when the judgment was entered below, you had complete diversity. And we spent 2 years in discovery. We went through a trial. I mean, does it make sense to do it all over again in state court? But then the other side, Justice Sotomayor, Justice Kagan, Justice Jackson kept saying, well, I mean, aren't we prejudicing the plaintiffs? Because, now we know that they should have been able to try their case in state court. And now they'll never have that opportunity. Harrington came back and said, well, the same thing is true when fraudulent joinder is incorrectly ruled upon by the district court the other way. That because then we would have had to litigate in state court, even if ultimately it had been determined that Whole Foods should not have been a party. So I get the sense that it's going to end up being based upon a prior decision called Caterpillar, where the Supreme Court basically said, yeah, plaintiff is master of the complaint, but that doesn't mean that it always gets its preferred form. That sometimes there may be other considerations like judicial economy that will override that. And I was getting the sense that at least here, and this was an excellent point that Harrington kept making, is that even the defendants or even the plaintiffs weren't arguing that somehow if Whole Foods had actually been a party in the district court, things would have come out differently.
Right.
Because the district court ruled on causation, meaning that you haven't proved that the baby food caused the autism. So if that's true, then who cares that Whole Foods sold it to you? Because it's still, causation. You haven't proved that the product caused the harm. And Harrington made a very good point, which is, in that case, truly, why does it matter that Whole Foods wasn't there? And she said, maybe in a different case, if Whole Foods somehow would have changed the outcome had it participated, but that's not this case. So I suspect it'll probably be 6-3. Justice Kagan was very concerned about a decision from last term called Royal Canin, which concerned a related issue of when federal courts can exercise supplemental jurisdiction over state claims. And she seemed to think that the challengers or the defendants' arguments here were inconsistent with that, but I don't think the majority of the court agreed.
Well, this will mark a difference in our fantasy SCOTUS predictions, because I'm predicting a win for the respondents here, and maybe a unanimous one. Although I thought the advocate for the petitioner here was great, like as good as you could do, and just really smooth, and really enjoyed it. I got the sense that decision from last year really matters to the court, that it does seem very similar to me. I remember that decision from last year where there was this, the federal claim had gotten dismissed, and only later on in the litigation, only the state claim remained. And they get to the Supreme Court, like, look, we litigated this whole case, and now you're telling us because this got dismissed, we have to go back and do it in state court. And they're like, yeah, it sucks, but that's what our jurisdictional rules are. It's what it is. Yeah. And I think it's similar here. Like, if you're not diverse, you're not diverse. And so, yeah, it's a big pain in the ass, but that's what federal courts can only exercise jurisdiction over things that Congress has given them jurisdiction over. And they don't have jurisdiction over not true diversity. And so, yeah, it's a big pain in the ass, but it's going to get kicked back. That's what sort of my prediction. But we'll see. It could go either way.
I have no prediction on the merits, but I just note that there is a rule in the somewhere that you can ask the district court uh, to allow an immediate appeal, or to
Right.
request that the appellate court hear a non-final order, which in this case would have been the order that said Whole Foods was properly dismissed from
Yeah.
the case. And so maybe that's a route that courts should do. Of course, in Federal Rule 23, or whatever the equivalent in the appellate rules, allows an appeal from a class certification order, which is also non-final, and maybe that would make the difference. It's Damien. You mentioned before that the issue is causation, but who decides that? It would be a federal judge or a state judge, and
Yeah.
so to say that it doesn't matter is true, but that kind of assumes that the federal judge and the state judge would reach the same conclusion, or treat the fact issues, if there are any, or et cetera, all the other considerations.
Or relatedly, that having the discovery into Whole Foods would not be able to establish. Maybe you could establish causation. Maybe you could establish some joint liability there. I mean, this to say that the outcome would have 100% been the same, and I think this was the point of some of the justices, is assuming that the forum doesn't matter. But we have this whole doctrine of plaintiff gets to pick their forum, and because there are strategic advantages, and either you believe that or you don't.
Yeah, then again, though, I would say, though, like, when a district court remands a removal, says, no, you can't remove it, that's not appealable.
Yeah.
And yet, and that definitively deprives the defendant of what otherwise would be the proper form. So, I don't know, I haven't read this Caterpillar case, but Harrington relied upon it pretty heavily. I think the facts are a little different there, because there, the quote-unquote fraudulent party was definitively settled out of the case.
Yeah.
And before final judgment was entered. But yeah, I mean, it could go, sure, it could go either way. It just seems to me that that there are strong judicial economy arguments.
But that was true last year with the supplemental jurisdiction case.
Yeah.
And that's
Yeah,
true. It's true in criminal trials. You go all the way through.
That one concerned dog food, whereas this is baby food.
Last point on this. I will say I did agree that the fact that the plaintiff could have filed an interlocutory appeal here, I found like pretty strong. But then, like, thinking about it a little bit deeper, if this is the rule, then can't the defendant also file an interlocutory appeal to shore up that decision is correct? So
Yeah.
maybe that cuts a little bit both ways.
Well, no. You have an asymmetry there, because if the court determines that Whole Foods is a proper party, that means there is no removal jurisdiction, and so the order would be a remand.
No, I guess what I'm saying is if you win and kick Whole Foods out, can't both sides seek interlocutory appeal of that just to get the circuit court to affirm it? So even the side that won, could they seek interlocutory appeal?
I mean, I wonder if there's a standing issue there, other justiciability, because the defendant there wouldn't be harmed by the order.
By the order, yeah, maybe. Yeah. Well, that's completes the arguments. It's been a couple days now since the big tariffs argument, and I did watch your guys' show, and you did great.
Highly rated, I'm sure.
Well, you'd be surprised. I did get, I told Oliver this, but someone at NLC recognized me from our show. So that was pretty cool.
That's great.
Getting famous. And it wasn't Dan Lennington, our super fan. But yeah, it's been a couple days since any other thoughts on the tariffs argument? Have you read some of the articles that have come out, and where are your opinions now?
Well, it's interesting. So yesterday, actually, I gave a presentation for the American Association of Agricultural Lawyers at their convention in Scottsdale. I was on a panel with Michael Kimberly, who's also a prominent, he is a prominent Supreme Court litigator. He actually has a case in January concerning sovereign immunity for the New Jersey Transportation Agency. But in any event, he made a comment, and I agree with him, because he said he listened to the argument, and then he saw the immediate commentary afterwards saying, Trump tariffs in danger, and he said that was not at all the attitude, the impression that he got, even though he's against the tariffs. He thought that yeah, it's actually a lot more nuanced than that. And if you would just listen to the first part with the Solicitor General, sure, I could see how you could add that. But as I was talking with Oliver on the show, to me, the nadir of the argument for the challengers was when Neil Katyal basically admitted that licenses are more or less economically indistinguishable from tariffs, and B, you could collect fees with licenses. That to me, because Justice Barrett was really pushing on that. She wasn't so much convinced that regulate importation necessarily meant you could then tariff, but she did think that when the phrase said by licenses or otherwise, and Gorsuch as well kind of hit on that. So that I thought was the low point. But then again, there seemed to be a lot of concern about not having a limitation on the revenue-raising aspect here. Mm-hmm. And that kind of harkens back to the Consumers Research decision from last term, where the challengers there contested the FCC tax for funding the Universal Service Fund, and the court upheld it because it read into the statute a ceiling as well as a floor for it. And that's, whether you have that here is an open question.
Yeah. Oliver, any additional thoughts?
I agree with Damien. I thought at least the headlines I saw were more critical, or more that they did read too much into the questioning, and to say that the justices were universally or uniformly skeptical of Trump's claims here, I think is wrong. But I still think the tariffs get invalidated. My gut says that the three progressives will vote against Trump on pretty much any ground, although Kagan will be a little more of a stickler. I think you can get Gorsuch on the major questions doctrine, and I think the chief wants to write it. And my cynical thought is that the chief wants the court as an institution to push back against the presidency, and that this is a good case to do it. And Damien, what was the last point you made? I did have one thought on
the licensing stuff.
Oh, the licensing. Yeah, I didn't quite get the argument. I understand that the point that the Sauer, the SG, that the government's lawyer was making the point that these are regulatory tariffs, and therefore the intent isn't to raise any money. As Damien and I talked about before, he said that if we didn't raise any money, that would be ideal, because that means the governments or the other governments are coming to the table to negotiate. But I thought that hurt the argument, because if leverage is the key, then just announce an embargo. That'll get them to the table right away if the issue is leverage. And yes, tariffs can have a regulatory intent and without an intent to raise taxes, but the Constitution doesn't divide that out. It says that the tariff power is Congress's, regardless of the intent. So that's just my personal 2 cents. There's nothing to do with what the justices will actually do with that.
Well, yeah. There was that point where the Chief Justice said that, yeah, this is a tax, but it's a foreign-facing tax.
Mm-hmm.
So yeah, I don't think that he's buying this Solicitor General's argument. But the licensing thing to me was significant, because every time either Neil Katyal or Benjamin Gutman was asked, but you say they can't do tariffs, but they can do this, that, and the other, and that just seems like if he can totally cut off trade, why can't he do something less than that? Yeah. And the response was, well, that's not revenue raising. That's not revenue raising. That's not revenue raising. Oh, licenses. Oh, okay. Well, yeah. Actually, you can raise revenue, and especially when you go back to the history. President Lincoln had the 4 cent a pound license fee for importing cotton during the Civil War from the rebellious states. So that's why I thought it was problematic. I think the Chief Justice, I agree with you all. I think he might end up writing it. At least, you ask me right now, I think he might write to affirm the tariffs, at least theoretically. Maybe not to say every single tariff is okay, but I think, he's going to say, sure, it's revenue raising, but it's foreign affairs. I don't, but it could go either way. It's very close.
Well, I'll break the tie on the licensing point just briefly. I think the response there was that the licensing that's authorized by this statute is not revenue raising. It's more of like a permission slip. So this statute doesn't allow, if you did do licenses for 10x what the actual cost would be, that they would raise the same problem as tariffs. So I do think they had an answer to that. I heard what you guys, I listened to you guys' show, I listened to the argument, I've read a little bit. I think it's going to be, like, if I'm putting my money down, I would put it in that the tariffs will get struck down. I just think that the administration here has to sort of run the table with all of these theories. It can't be major questions. It has to be in the statute. It's not non-delegation, and it just seems that there's enough pitfalls where the other side can cobble together 5 votes, and that's why I tend to think that it's not going to be in a majority opinion. I think you'll have something like a 3-2-1 where no opinion controls, but there's a judgment invalidating the tariffs. I thought the big worry that I had for the non-tariff side coming into the argument was there's so much money that would have to be returned. What is going to be your answer to that? And I thought Katyal, although I didn't think he did a great job, I thought he had a pretty good answer to that question, where he said, look, we've done this before. You can stay your mandate. Congress can pass new appropriate legislation. There's things that can be done. It's not as big of a deal. It's a lot of money, but there are ways to get around it. So with that answer, I think that was pretty good. I think that the court will strike it down.
Would be interesting if that decision is what then convinces Congress, the federal government, to reopen, so they can pass a ratifying legislation.
Do you think we'll get this opinion before the new year?
Yes. Or soon, by the end of January for sure.
I'm not. I wonder if the court might want to wait until the government reopens, precisely because if they're going to overturn the tariffs, they
well.
want to get.
Well, we've been. Thank you guys for coming on Friday. Oliver for joining us at the National Lawyers Convention. We'll be back on Monday with a preview of the last week of the year. I don't think there's any arguments in December. Is that right, or is there December arguments?
No, there's at least one. The Slaughter, the
that's right.
Case.
Oh yeah.
So it's the last argument of November. There's only next week's is the final arguments for November. We'll go over those and we'll have a recap episode later in the week. Thanks, guys, and we'll talk to you soon. And Damien, when we stop it, wait for it to upload.
He knows now. He knows that. He knows to show up. He knows to show up at noon and not to hang up right away. We're getting there.
All right. See you guys.